Hey everyone, and welcome to this explainer on forensic psychology. Okay, let's dive into this, because today we're unpacking one of the absolutely most fascinating intersections in our entire society. I'm talking about the exact point where the messy, unpredictable realities of the human mind completely collide with the rigid, black and white structures of the law. We're going to take you from the absolute basics of a crime scene straight through to the high-stakes, real-world decisions made in the courtroom.
So here's our syllabus and roadmap for today's crash course. First up, we'll map out the anatomy of crime. Then we'll enter forensic psychology. From there, we'll see exactly how psychology meets the law, put the mind on trial, and finally, wrap the whole shebang up with ethics and careers. I promise you a clear, organized journey through some pretty complex stuff.
Section 1. The anatomy of crime. Defining the rules. Before we can even begin to understand the psychology, we've got to establish the baseline rules of the game. So, what exactly makes a crime a crime? You might be wondering that. In the eyes of the law, it's rarely just about doing something bad. There are highly specific, almost rigid building blocks that literally have to snap together perfectly for the justice system to officially label an event as a criminal act.
Fundamentally, a crime is an act, or even a failure to act, that violates a specific law and is punishable by the state. But the real legal battles, those happen over two incredibly vital elements: concurrence, which means the act and the intent happen simultaneously, and causation, which is proving the act directly caused the harm.
And this brilliantly illustrates the absolute foundation of criminal law: actus reus versus mens rea. Actus reus is the physical guilty act. Mens rea is the guilty mind, or the intent. For a crime to actually occur, you generally need both. Think about it like this. If someone accidentally harms another person, there is no mens rea. There was no guilty mind, no intent to cause the harm. So it's usually not classified as a crime in the traditional sense, but rather as negligence. You literally need the mind and the action to align.
Beyond just intent, crimes are classified by how the legal system actually responds to them. Here's a quick legal cheat code: cognizable versus non-cognizable offenses. Cognizable crimes are severe. Think violent crimes like murder, where police can make an arrest right there without a warrant. Non-cognizable crimes are less immediately dangerous, like defamation, where the police actually need to get court approval before they can make an arrest.
Section 2. Enter forensic psychology, bridging the gap. Let's transition from the crime scene itself to the professionals who actually analyze it.
Forensic psychology is this vital, crucial bridge between the strict letters of the law we just established and the super messy reality of human behavior. By definition, it's the application of psychology to law and legal processes. It takes these complex psychological principles and applies them directly to criminal investigation, legal proceedings, and even the rehabilitation of offenders. Basically, it's how we make sense of the why behind the what.
Now, what's really interesting about this slide is how cleanly it separates these three often confused fields by their focus. Legal psychology focuses strictly on behavior within the legal process, like how juries make decisions. Criminal psychology drills down into the individual offender's mind, and criminological psychology zooms all the way out to look at the broad societal causes of crime. Three very distinct lenses, all of them absolutely vital to justice.
Section 3. Psychology meets the law, the legal arena. Let's look at the practical application of how these disciplines actually work together.
I found this breakdown completely fascinating. The relationship actually functions in three distinct directions. First, you have psychology in law, which is the highly visible stuff, like expert testimony on the stand. Then psychology of law, where psychologists put the legal system itself under the microscope to analyze things like jury decision-making. And finally, psychology and law, which is the broader interdisciplinary field where both sides work together to understand human behavior, intent, and even eyewitness reliability. Because the legal system is just so massively vast, forensic psychology has fractured into all these specialized disciplines to handle it all. You've got criminal profiling and investigative psychology directly assisting the police. You have forensic clinical psychologists conducting heavy mental health evaluations. You have correctional psychologists planning out rehabilitation in prisons. And the scope of this is only expanding. Professionals are now applying these exact same skills to really modern areas like cybercrime analysis and the psychology of terrorism.
Section 4. The mind on trial. Courtroom concepts. This is where we get into the most dramatic and honestly the most misunderstood concepts in the entire courtroom.
Before any kind of psychological defense even enters the room, we have to acknowledge the absolute baseline, the presumption of innocence.
Innocent until proven guilty, right? Because of this, the burden of proof lies entirely on the prosecution to prove guilt beyond a reasonable doubt, which makes psychological evidence an incredibly high-stakes game.
So the crucial point is understanding the difference between these two major psychological concepts, competency to stand trial and the insanity defense. People confuse these all the time, but it literally all comes down to the timeline. Competency is all about the defendant's present ability. Right now, today, sitting in the courtroom. The insanity defense is strictly about the defendant's mental state in the past, at the exact moment the crime was actually committed.
Let's look a little closer at competency to stand trial. To be deemed competent, the accused must have a rational and factual understanding of the court proceedings happening against them. But even more importantly, they must have the cognitive ability right now to consult with their lawyer and assist in their own defense. If their present mental state prevents this, the trial literally cannot legally proceed.
The insanity defense, on the other hand, relies heavily on what is known as the McNaughton rule. Under this rule, a person is not held legally responsible for their actions if, at the time of the crime, their mental state was so severely impaired that they were completely unable to understand the nature of their act or unable to understand that what they were doing was wrong. Going back to our earlier point, no mens rea, no crime.
Section 5. Ethics and Careers, the Daily Reality. Let's transition into the real-world implications and ground all this theory into the daily lives of the professionals doing the work.
Imagine you are a clinical forensic psychologist and your client, a known offender, confesses to you that they are planning to severely harm someone tomorrow. So, do you protect their secret to maintain client confidentiality, or do you break that trust to warn the public? That scenario, that is the ultimate ethical dilemma in the field. While confidentiality, informed consent, and total objectivity are the absolute bedrock ethical principles for any psychologist, they are actually overridden by one major exception: the duty to warn. If there is a credible, imminent threat to public safety, the forensic psychologist has a strict legal and ethical obligation to break confidentiality and warn the potential victims or the authorities. Safety first, always. Let's move to and see how this builds into tangible career paths. The application of these skills is just incredibly diverse. You could be a police consultant assisting with complex interrogations, an expert witness testifying on the stand, a correctional psychologist working deep within the prison system to plan rehabilitation, or even working alongside NGOs for victim counseling. The legal system simply could not function fairly without these specific roles.
Which leaves us with one final, and honestly very provocative theoretical point to ponder. We've established that psychology explains the criminal intent and the rigid law determines the punishment. But what is considered a crime is actually socially constructed. It varies entirely by culture and by era. So if the definition of a crime is just an invention of society and the mind is just reacting to its environment, who really decides what a crime is? Definitely something to think about until our next explainer.